We're on. There we go. Okay. Thank you, everybody, for coming back after a wonderful lunch. We are here to talk about class action certification and talk about it across multiple jurisdictions. I am Christine Azar. I'm with Russ Consulting, Senior Vice President. We do settlement, notice, and claims administration primarily in the United States. I am a former class action plaintiff's securities litigator as well, and spent a couple of years also working in litigation funding, which you all got to hear about earlier today. I am joined to my left by Ryan Clarkson. He's the founder and managing partner of the Clarkson law firm based in Malibu, California. Ryan's represented plaintiffs in hundreds of consumer class actions, and mass arbitrations, including privacy and data breaches, defective products, illegal employment practices, securities violations, food and cosmetic mislabeling, and insurance bad faith. And to Ryan's left is David Gadsden. He's a partner at Baker McKenzie in Toronto, so he will be bringing us the Canadian perspective. He's chair of the firm's Canadian Class Action Group. He has represented both plaintiffs and defendants in a myriad of class actions, including competition cases, professional services negligence, products liability, and securities fraud. And he also has extensive experience with large business dispute litigation and arbitrations. And to his left is Damiën Berkhout. He's managing partner of the Lindenbaum law firm based in Amsterdam. He will be bringing us both the Netherlands and broader EU focus on class certification. He has extensive experience in complex litigation with a focus on class actions, competition litigation, commercial disputes, and corporate litigation. He is ranked as a next generation partner by Legal 500 and has published over 20 peer-reviewed articles on a variety of topics, including class actions. So we thought we'd start first with a little bit of background. So what are the class action certification requirements and the process in each of the respective jurisdictions? And Ryan, if we can start with you to talk about the U.S.
Sure. Happy to kick us off here. Thank you, Christine. And thank you to GLG. I love this conference, and Lisbon is beautiful. Feels a lot like our home city of Malibu, California, so the climate feels good. And yesterday hit Cascais, which was, I guess, the Malibu of Lisbon, as I understand it, and lived up to its reputation. It was quite nice. So, good starting point. U.S. class certification requirements. Many of you have been doing class actions for decades, especially those of my colleagues I've seen from across the pond, so you can tune this out probably, but a quick primer. So Rule 23, Federal Rule of Civil Procedure 23 is the rule that lays out the class certification requirements in the United States. You need to meet two kind of broad categories. There's a list of prerequisites under Rule 23A, and those are the prerequisites that we all know very well: numerosity, commonality, typicality, adequate representation. We'll get into those a little bit. And then the 23B requirements. You have to also satisfy one of the 23B requirements. And depending on what the goal is of the litigation, you'll be certifying under one or more of those 23B requirements. So 23A prereqs, what are they? Numerosity means that you have to have a number of aggrieved individuals that are so numerous that the rules of traditional joinder are ineffectual and impracticable. And so what's the number? Well, sometimes, courts have interpreted it as at least 40 for the most part. In rare circumstances, you might be able to certify a class with as few as 12. But for the most part, we don't see class actions with fewer than, say, a few thousand. I see my colleague, Glenn Danis, who can you all still hear me?
Yes.
All right. We're going to improvise here. I'm going to hold this. My partner, Glenn, here runs our appeals and writs department. And shameless plug, one of the best appellate attorneys in the country, if you ask me. But his expertise arises out of trial work in the wage and hour and employment context. And so in labor code violation class actions, you might have cases with as few as 3,000 to 4,000 aggrieved individuals. On the other hand, You have some cases that involve a lot more people, and I know many of you have prosecuted such cases. My partner, Jana Hart, who runs our AI and data privacy practice, she's involved in a case right now involving a data breach it's against Ticketmaster and Live Nation. That is a company that helps facilitate concerts and sells tickets, as you all know, I'm sure. And I'm sure you do because it involves 540 million aggrieved individuals. So maybe another manifestation of the Taylor Swift effect. I don't know. So that's numerosity. Then you have commonality. You need common questions of law or fact common questions of law or fact. We'll get into predominance in a second because that's a B, 23B requirement. So these common issues should really drive the litigation. They shouldn't be ancillary. They drive the resolution of the litigation. The third prereq, typicality. Your class representative has to have claims that are typical of the other members of the class he or she seeks to represent. And I say he or she because we're representing individual class representatives typically, sometimes small businesses, but largely these are consumers, investors, insureds, that sort of thing, as opposed to qualified entities who are, like they have in the EU context, a very different thing. So typicality typically means, you just have to have an injury that's coextensive with the other members of the class. And then the fourth prereq is adequate representation. And we're looking at this in a two-part inquiry. The first is the class representative adequate? And the simple question one might ask is, does the class representative have any kind of conflict of interest with other members of the class? But class counsel also has to be adequate. And so there we're looking at competency in terms of the subject matter. You want skilled, qualified lawyers that are prosecuting these cases. And then, you need to have resources to support the litigation. So firms that are well-heeled with financial resources or access to them, and also personnel. So it doesn't mean you need to have 30 lawyers like we do at our firm, or 1,000 lawyers like John Yanchunas has at Morgan & Morgan, but you should have a solid team and co-counsel, if necessary, in order to marshal the necessary resources. So those are your 23A prereqs. If you meet all those prerequisites, you then move on to 23B. And 23B is the second part of it. You need to satisfy either B1, B2, or B3. B1, these are kind of rare class actions. It has to do with situations in which you'd have inconsistent judgments, and courts want to avoid that. And so let's say you have a case against, a power company or something that has caused injuries to a neighborhood or contaminated drinking water, let's say, and a number of aggrieved individuals decide to file a case seeking different forms of relief. That is something that a court would say, let's band them together, let's certify it under B1 and litigate it as one as a class action. Also gives predictability to the corporate defendant in terms of what they may be forced to do as a result of that class action. B2 is a situation in which you're bringing a class case in order to effect a change in corporate behavior. So you're seeking declaratory relief. You're seeking injunctive relief, okay? A cessation of false advertising, a change in a way in which a corporation is paying its employees, something like that. B2 is how we're certifying that case, and what we're trying to do is prevent future harm, okay? And then B3 has to do with, we typically see B3 in monetary cases. So we're seeking a financial remedy, and B3, interestingly enough, just came into being in 1966. I don't know if you all know this, but Federal Rule of Civil Procedure goes back to like the 1930s. And so it's been around for about 90 years. But it only authorized B1 and B2 class actions. Well, back in 1966, the advisory committee made some recommendations to the Supreme Court, which adopted those recommendations, and they instituted B3. And B3 now provides for financial remedies in financial class actions that provide for damages and restitution and that sort of thing. So what you need there is you need the common issues to predominate, and you need to prove to the court that the class action is the superior form of adjudication as opposed to, say, an individual action. So that's our foundation, and I think that is a good launch point to discuss how other jurisdictions do it. So I'll pass it off to David.
Great. Thanks so much, Ryan. Really appreciate that, and thank you, GLG, for having us here. Lisbon this time of year is not like Toronto this time of year, so I'm very grateful. Also grateful for Ryan's explanation, because I'm going to piggyback from that. Canada's certification system is largely similar to what Ryan just described in the US. Each province and territory does have its own test, its own legislation, but generally speaking, all of those tests have the same element, and they're fivefold. So number one, a pleading must disclose a cause of action. And the analysis on that step is based on the pleading itself. The facts in the pleading or the allegations in the pleading are taken to be true. So it's not an evidentiary test. It's not something that the plaintiff will file evidence on. You just take the pleadings as if they're true, and there must be a cause of action, at least one cause of action pleaded there. Number two, there must be an identifiable class of 2 or more individuals. The rule is 2 or more. I don't think I've ever seen a class action that's had less than 10 plaintiffs, but theoretically you could bring a class action on behalf of 2 people, so long as they have similar issues and that those issues could be resolved on a class-wide basis. Number 3, there must be common issues, issues that are common to the class and can be resolved on a class-wide basis. Number 4, preferable procedure. Again, the class action that's being proposed must be seen to be the preferable means by which to resolve the common issues to the class. And then 5, similar to the test that Ryan described, there is an adequacy step in respect of the representative plaintiff. The representative plaintiff must be competent, must have interests aligned with and not in conflict with the proposed class. And the representative plaintiff must propose a workable litigation plan, and that's something that, frankly, is crafted by plaintiff's counsel, but it's part of the application record when a plaintiff goes to move before the Canadian courts. The courts want to be certain that the representative plaintiff is suitable, but also that there's a workable and well-crafted, well-considered plan for the litigation as far as the plaintiff's intention on moving it forward. Some recent developments in 2020 came into play in Ontario, which is where Toronto's based, and it's one of the more popular jurisdictions for pursuing class actions. And these amendments relate to the preferability and the commonality steps in the test. And what they do, in essence, is bring it a lot more closer to the 23B procedure that Ryan just described, and specifically, under the new amended legislation in Ontario, a class action must be superior as compared to other potential means of resolving the dispute. So that superiority concept has been imported, and that comes from the US legislation. And then secondly, the common issues must predominate over the individual issues to be resolved. So it's been really interesting to see how the impact of those amendments, because I mentioned Ontario was a very popular place to commence class actions. That has changed somewhat after these amendments came into play, because it's the only jurisdiction in Canada currently that has that heightened threshold, or more, I'll say, defendant-friendly test. And so now what we're seeing is actions that would have been started in Ontario are now being started in other plaintiff-friendly jurisdictions, namely British Columbia, Quebec, and our federal court. So that's been very interesting to watch. The other thing I'll mention that differentiates the certification process in Canada as compared to the US and some other jurisdictions is that in Canada, certification is fought before there's any discovery. So it's the first major battleground in the proposed class action, but it's done without discovery. So that means there's very limited evidence that makes its way into the application record when the courts are determining whether a proposed class action should go ahead. Typically, it's an affidavit, sworn affidavit from the representative plaintiff, indicating they're not in conflict, they have interests that align with the class, why they're suitable. There might be some publicly available documents appended to a clerk affidavit from the plaintiff firm that bolster or substantiate the allegations in the claim. And then often there's expert evidence, particularly in cases like competition claims where there needs to be some demonstration that there's a workable method of calculating damages. And then the defendant will respond in kind. There's cross-examinations, and the certification motion is argued typically over a period of several days. But all of that is done without the benefit or perhaps the burden of having done full-on discovery in advance. So there are pros and cons to that approach, but it is an interesting and different feature to our system as compared to the U.S. I'll pass it over to Damiën.
Yes, thank you, David. And thanks for the organization to invite us in this beautiful location, of course. From the Dutch perspective, things are very different. They're very similar in a sense because I know it's a lot of language that we would also use, translated, of course, in Dutch. But in essence, we don't have a pure certification step in our system. Instead, it's a part of the larger preliminary stage test, whether or not the representative is allowed to continue with this case, and whether or not the definition of the group as provided by the representative is correct. So the court establishes what the group is, but the plaintiff itself actually brings forward the definition of a group, which is interesting, I think. Just to take a step back, how the WAMKA works, you need to have a foundation, or as you probably all know, the beautiful word nowadays, a stichting that has to bring an action. It's either a stichting or an association. And that foundation needs to prescribe that I am here to represent the interest of this particular group. Then there's a quite steep test in the beginning of the procedure, whether or not you have standing. And if you meet that standing test, you go on to the next step. And in that step, we see our type of certification. And there the first question is it efficient actually to do this case in a class action? And I had to smile when you said, in theory, 2 people can be a class. I don't think that the Dutch courts would go that route, but we do have had class actions with as little as 40 people in the class. On average, the classes nowadays on the WAMKA are much larger, hundreds, thousands, or millions of people living in the Netherlands, generally speaking. The next part of the test, if the court states, well, it's more efficient to resolve this case in the WAMKA, the court will also look whether or not the group is sufficiently similar. There is quite a bit of case law that similarity does not mean that the interests need to be aligned. They can be conflicting. There can be large differences between the group. And I think very important, more recent case law has been in the privacy collective case where the appeals court has found that it's quite possible ex ante at the beginning of the procedure to have a group that includes individuals that have not suffered the loss. Right? There was an important question in our certification process whether or not you're able to bring a litigation on behalf of groups with individuals that might not have any damage. That is possible, I think, and the Court of Appeal agrees for now at least, so we'll wait and see whether or not that's brought to the Supreme Court. So is it more efficient? Is there sufficient similarity? And if those 2 conditions are fulfilled, in principle, you can continue. In case of a damages case, there is another condition, which is that the size of the claim has to be sufficiently large to continue. That's a part of the test as well. And then you go to the 3rd step of the preliminary stage where the court needs to decide, assuming there are organizations or representative organizations that have standing, which one is best suited to be the exclusive representative. And at that stage, the court also defines the narrowly defined group that is to be represented by that particular representative organization. And it's in theory possible that the court will say, I'm going to define several groups and I'm going to appoint several exclusive representatives. Interestingly enough, the courts also think that they can appoint co-exclusive representatives. I find that term quite confusing, but that's also a possibility. And then the final step of this process is the WAMKA is an opt-out system. So the final step is that the individuals will get an opportunity to opt out of the group. So an interesting process. In practice, of course, people tend to not do anything because they're not aware or they're too lazy to step out of a group.
Or they don't want to.
Or they don't want to. That's also possible. Yeah, yes, indeed. And generally speaking, the opt-out is obliged, although increasingly the courts have sometimes, in some cases, decided that it's not necessary to have an opt-out period of time.
Excellent. Thank you all. So some of the issues that come up a lot in the class certification process involve the composition of the class. So questions arise about, can you identify the class members? Are they ascertainable? Can you find them? Can you get notice to them? And can you get them paid? And these are, they're near and dear to my heart as a class action settlement administrator, but they're, issues that have to be resolved even if they're not, a check the box kind of thing. But we want to know that the money's going to ultimately get to the people that are part of the class. So Ryan, what do you see in the U.S. Evolving in that area?
Yeah, so to talk a little bit about the process in the United States, we talked about the requirements. Class certification typically happens when the case is at issue. When is a case at issue? Well, typically a case will be filed as a class action, and then a defendant will will move to dismiss. They'll file some kind of pleadings challenge, let's say a jurisdictional challenge, or maybe they move to transfer that case, or maybe they challenge the standing of the plaintiff to proceed in the case. Assuming that the plaintiff can overcome those initial challenges, then the case is now at issue and we are on to class and even potentially merits discovery. Sometimes, especially in specific federal jurisdictions, courts will bifurcate class and merits discovery. Okay, so you may just be in a situation in which the court has only authorized class discovery, and you'll be seeking evidence in order to build up your motion for class certification. Now, you have to meet all the requirements under 23A and 23B, but what does it mean? What kind of evidence does one have to muster in order to overcome that class certification barrier? Well, what we're seeing a lot of are challenges with respect to establishing class-wide damages. Okay, so it's a commonality challenge. We see issues relative to the class representative. Is the class representative's claims typical? Is the class representative adequate? Which is one of the reasons why you have to vet your class representatives so well. You really need to have a champion class representative, someone who, even though the loss may be relatively insignificant, say financially, they really feel vested in the outcome of the case. So you're looking for that true believer, especially in low-cost, let's say, consumer goods cases, where the bulk of the money is going to be going to the rest of the class. So we're looking for folks that really want to put the interests of their class members, their fellow class members, on par or even ahead of their own. So at class certification, to answer your question more directly, Christine, when we're looking at notice, we want to be able to identify and then ultimately notify class members. And so depending on what type of case it is, you might be able to gather evidence which identifies the specific class members, either through class member lists or contact information from vendors and that sort of thing, and their identity, in which case you can give direct a notice, or you might have to do a published notice campaign in which you're, let's say, using social media or pay-per-click or emails. Well, I guess that would be more direct notice, but kind of an online campaign. So depends on what type of case it is, but you want to be able to identify those folks because there's a due process requirement. Typically, you need to notify 80–85% of folks in order to pass muster for due process. Certainly in the settlement context, but notice is an important one. And then the other thing is damages. You're thinking ahead in the case about if this case is certified and ultimately tried, how am I going to prove damages on a class-wide basis? Some judges require just the ability of the plaintiff to demonstrate that it's possible to determine damages on a class-wide basis at the remedial stage. Other judges want to front load the litigants, and they want to see the goods at the class certification stage. So you may need to have a damages expert, an economist, a conjoint survey analyst, for example, put together a full report in order to evaluate what the damages are at class certification. If you do that, and I'm a big fan of that, frankly, because I think it runs, you run less of a risk that a motion for decertification is filed, and if certification is challenged at the same time as, say, the merits are, with a concurrently filed motion for summary judgment on the merits, then I have all of my evidence in order to defeat that motion and show the judge that there are genuine issues of material fact that should go forward and should be tried.
David, do you see that as well?
Yeah, so very similar. So I'll start with notice and then move to damage. Notice is quite similar. I'll bring you the defendant's perspective because that's who I act for now. Christine mentioned I for plaintiffs as well, but that was prior to joining my current firm. I worked at a plaintiff side class action firm. On the defendant side, notice is really largely driven by the plaintiffs, and it's done after certification, whether certification is successful on a contested basis or certification is done on consent as part of a settlement. I would say defendants don't typically have a lot of say in what the notice looks like, except for obvious things. For example, if there's a settlement and a notice is going out, defendants would want to make sure that there's nothing pejorative or offensive about the settlement, or that there would be language in the notice that makes it very clear that the settlement is on a without admission of liability basis, that kind of thing. Theoretically, I think, and you should know Canada largely, there's a few minor exceptions, but generally speaking, it's an opt-out regime. So if there's a settlement and notice is going out, theoretically, a defendant might, lean toward having a narrow form of notice, so that means there are less opt-outs, more people captured in the class, and defendant can walk away knowing that there's not going to be any opt-out claims or significant opt-out litigation to follow the settlement. You get that finality that I think often forms part of these bargains. So having said that, I wouldn't advise my client to try to make that argument to the court, or publicly assert that there should be a more narrow form of notice. The court will come at this process considering the best interests of the class members and fairness to those class members. And so, that's going to be the guiding principle, and notice is carried out on that basis. What is the best process to put in place that will be fair, that will reach the most class members practicable. The direct, indirect notice methods that Ryan spoke about are also used in Canada. I will say that the identifiable class piece is of interest to defendants, but more at the certification stage. So when you're thinking about notice, how am I going to notify these potential class members? Defendants counsel will go through that analysis early, because if they can make an argument that there's no way that you could notify class members, then that's an argument we're going to use at certification on that second branch of the test, the identifiable class piece. And then in terms of damages, class proceeding certification in Canada, it's not a merits-based analysis. It's intended to be completely procedural. Merits have their way of leaking into the equation, but so damages do not need to be assessed, but they do need to, in certain actions, particularly competition claims, it does need to be shown by the plaintiff that there is a workable methodology available that would allow, so in the case of a price fixing claim, that would allow class counsel or the plaintiff to calculate an overcharge or show that an overcharge has passed, to the various purchase levels in the alleged price fixing scheme. And so, unfortunately, for the defendant's perspective, there's been a very low bar set on that, coming out of the Supreme Court of Canada in a case a few years ago, Godfrey and Pioneer. So that law is set quite a low bar. Like I said, plaintiffs don't need to show actual calculations, just that a calculation can be done. And there's not been yet a class action trial in a competition claim. So we've never had a merits decision or hearing in a competition class action in Canada. So we've yet to actually test all of these plaintiff theories that come forward at certification. So we're eager for the day that happens. But at this point, that is yet to occur.
So Damiën, I'm just curious if I can jump in. Since you handle the class certification at the beginning of the process, assuming the court approves the action to move forward, do you have to notify all the class members at that point?
Yeah, yes, indeed. So this is a part of the opt-out system in essence, right? So you need to opt out, and then you need to notify the group of the opportunity to opt out. And actually, you're notifying them, I am now the exclusive representative of your interests. If you don't want to be represented, please opt out of this claim. And in the Netherlands, there's in essence a debate between parties of what that message should be thus far. Not in all of the cases, but in many of the cases, this is a part of the debate. Like, what does this notice have to entail? What does it have to contain? And the legislation is interesting because it's a bit old-fashioned. It presumes that you know, at least you know a part of the group, which is actually true in almost all WAMCAs. And then you would send a letter to those individuals. And then separate from that, you also need to publicize the decision on your website, and you need to go to some newspapers, etc. So you need to have a sort of a broad notification test. That's the theory. In practice, the court, in debate with parties, determines what's the best way to get a notification out. And a good example is a recent case of last in this year, which is the Temper case. There it was determined like all of the group members are in essence people that have used this platform. You, defendant, have the email address of all these individuals, so you're going to send the email. And that's going to be the notice, and this is what's going to be in the notice, right? So there's a more substantive debate of what a notice does entail. And thus far, in most cases in which the WAMCA has passed this stage, where there is a certification, so to speak, you can see that the court is hesitant to give an analysis of what, which is interesting, I think, what the claim entails, right? So it's a very formal notification. There's this case that's about this topic. This is the party that has been appointed. This is your opportunity to opt out by sending a message to the court. So it's a very particular process, I would say.
Okay. Well, while you're talking, perhaps you could talk a little bit about some of the challenges you're seeing in class certification. As we all know, it doesn't always go completely smoothly.
Yes, so perhaps to begin with, a challenge I think in the Dutch system has to do with a very unuseful piece in the legislation, which is the conditions under which you're appointed to be the exclusive representative. Because those conditions include the size of the group that you propose to represent and the size of the claim that you represent. Those are two explicit factors in the statute that the court should consider when determining who to appoint as the exclusive representative. And those two conditions simply do not make sense. Right? They do not benefit the system, because what happens, for example, a practical example is the TikTok case in the Netherlands. There you have a couple of plaintiffs, and full disclosure, I was one of those plaintiffs that thought long and hard about what class should we represent, and we decided we are going to represent Dutch children because they have been harmed, particularly by TikTok. There's actually a different type of breach with this particular group, so we're deliberately not including the adults in the group. And then what happens is a competing claim can then look at that and say, wait a minute, if I also represent adults, I can present to the court that I'm better suited to be exclusive representative because my group is broader and my claim is larger, which is exactly what happened in the TikTok case, right? So the legislation is not properly suited for the court well, I should rephrase that. The court is supposed to include factors in the deliberation which should not be relevant. I should immediately say that the court in TikTok eventually stated, well, it's all very interesting, but I'm going to appoint my client, in this case, the Privacy Collective, as the exclusive representative for children, and the other party, the sort of competing claim, was appointed for the adults, right? So there's a solution here, but this was really a solution which frankly went a bit outside of the scope, I think, of the legislation. So that's one problem. Taking a step back and looking at the European system, I think there's too little harmonization, right? So if you have a case in Europe, and you often have a case which doesn't stop at the Dutch border, doesn't stop at the Belgian border, it goes all the way here to Portugal and to Germany and everywhere. And then when you're trying to help, for example, in the consumer case, the people that are part of the group, you need to do a lot of work, especially in the notification process, because the rules are different everywhere. And we now have the Representative Action Directive. And I was frankly quite disappointed that in that directive, in essence, the European Parliament and the European Commission and Europe is saying, well, the member states should devise how they're going to do this notification process, and they're to decide how to work with this. And in practical terms, that creates, at the very least, form shopping. Now, I'm not necessarily against form shopping as a plaintiff lawyer nowadays, but when I was a defense lawyer, I was very much against form shopping. And as a plaintiff lawyer, I'm very much against delays, which are caused by the difficulty and the uncertainty in these rules. So I would prefer a little bit of more harmonization on this part.
Gotcha. So David, in Canada, what challenges do you see, or perhaps from the defense side, what hurdles are you able to put up to work against class certification?
Yeah, I'm happy to speak to that, Christine. And it's funny that Damiën mentioned forum shopping on one hand and delay on the other side, because we're seeing those issues in Canada as well. So I think the first issue we're seeing is when to sequence preliminary motions. And when I say preliminary motions, I mean pre-certification, whether that be a pleading motion to strike a pleading, whether it be a jurisdictional challenge or some sort of summary judgment claim. For the longest time, and there's always a pendulum effect happening, but for the longest time, it would just be part of the defendant's playbook to file preliminary motions and delay getting to certification for as long as possible. Sometimes those motions would be meritorious. There would be some validity to them. Sometimes they would be purely tactical. Then the pendulum shifted because one of the objectives of the class action regime in Canada is access to justice. And I think the courts and the bar was experiencing a very long road to certification when the defendants threw up these hurdles. So we then moved into a period where the courts would typically, and this would vary by jurisdiction and by judge, but the trend was the judge or the courts involved would say, let's just bring all these motions at certification. And if you're right that there's no pleading, or if you're right that there's no jurisdiction, we can decide that at the same time that we hear jurisdiction. So that's fine and in some ways more efficient, but on the other hand, it still takes a long time to get the certification. And if the courts don't have jurisdiction, from the defendant's perspective, isn't that something you should be figuring out right away? So the most recent chapter of this tale is that in Ontario, I mentioned those amendments to the class action legislation earlier. In Ontario, there's now legislation that's been added that says where a party wants to bring a motion that can narrow or dispose of the claim altogether, that motion shall by default be brought before certification. So now we're back to where we started in some senses, but it's actually statutorily imposed in Ontario. Other jurisdictions don't have that requirement, so this is another factor that is contributing to plaintiffs' counsel deciding not to file in Ontario and to bring their claims in other jurisdictions in Canada. The other area of challenge that from a defense perspective I'll raise is multiple proceedings, and this goes to the forum shopping point. We do not have a well-oiled, well-coordinated multi-district litigation system or regime like Ryan would be accustomed to. There is legislation that allows for class actions to be brought on a national basis, so someone could file in Ontario on behalf of Canadians everywhere. Someone can also file in British Columbia on behalf of Canadians everywhere, and this leads to conflicting cases often. So from a defense perspective, you raise a fairness argument. Why should I have to defend essentially the same claim in multiple jurisdictions at the same time when the result is going to be presumably similar or perhaps overlapping or perhaps conflicting if all 3 or 4 of those actions go ahead? The courts have some sympathy for that argument, and so usually that situation gets resolved in one of two ways. Either plaintiffs' counsel decide to form a consortium and work together, and what they'll do in that instance is they'll pool their resources, they'll share in any reward that comes from the ultimate judgment or settlement if there is one. And they would agree, let's stay the actions in, let's say, Ontario and Quebec, but we'll all agree to push forward in British Columbia. That works for the defendants because now you're just fighting one battle instead of 3 or 4. If that doesn't happen, if plaintiffs, and I should say the trend recently is that plaintiffs' counsel typically find that that's the best way to handle these things, and for the most part, they find a way to form a consortium. But it doesn't always happen, and if it doesn't, then it's usually on the defendant to bring a stay motion in one or multiple jurisdictions, arguing that it's unfair to have to defend multiple proceedings at once. And so the court will make a ruling, and typically the end result is that one of the actions will go ahead. It's a lot more risky for plaintiffs' counsel because if they're in the jurisdiction that the court decides is not going to go ahead, then they will have wasted significant resources trying to fight that battle, and it perhaps would have been a better strategy to form a consortium out of the gate.
Great. So Ryan, in the U.S., as we see often, class certification is a really pivotal moment in a case. In fact, can be really case dispositive. So what challenges are you seeing, and from the plaintiff's perspective, what do you do to get past class certification?
Yeah, it's a great question. And listening to Damiën and David talk about all of the challenges they face, we face similar challenges in United States cases. And it's not just at class certification, but it's also on the pleadings. And then it's also on the merits. And then if you're one of the rare attorneys that tries a case, then you're running into issues at trial. And certainly at class certification, you have to be prepared with all of your evidence on each of the elements. But in particular, I see a lot of challenges with damages. I see materiality challenges. And then also I see judges wrestling with the issue of if they certify this case, how is it going to be tried? And more judges are actually trying these cases to see what they look like at trial. I've got a colleague, Tim Blood, back in the States, who's tried 6 class action cases in recent years. That would have been unheard of, a decade or two ago. And so it got me thinking a little bit about something we like to do at our firm, which is given that judges have so many tools to get rid of a case, to dispose of a case, we recognize that we need judges who are partners with us on our case, that they are going to allow themselves to invest their time, their staff's time and attention into a case, because there are just too many off-ramps for judges at all of these various levels. And so what we think about are something we call Curry 30 cases. So my favorite NBA basketball player is Steph Curry. You guys probably know who he is. His number's 30. He's got, so we think about our metric as 30 Curry cases, okay? So 10 out of 10 on the merits, 10 out of 10 on damages, but 10 out of 10 on outrage factor, okay? In the EU, you have litigation funders who are gatekeeping what cases get filed. And so they're doing financial analyses to determine which cases are actually going to have the resources to prosecute. And I was astounded at the number that actually get greenlit or funded, 3 to 7%. I couldn't believe it when I heard that. Well, we don't have anything like that as a gatekeeping function, so we impose one on ourselves as a firm, and that is outrage factor. We want a 10 out of 10 on outrage. It should be a case that the court is going to consider and really feel is an important one, something that will benefit society, not something that's just a gotcha case or a technical violation. So that's something that we look at as a challenge we want to overcome in class cases as well.
Sure, that makes sense. So I'm seeing our time is dwindling here. I wanted to make sure there was time if anybody had any questions for our fine panelists here.
Good afternoon, Yana Hart, and I have a question for David. David, you were mentioning that in Canada, before any discovery, you have to essentially show that your case can be certified. And you mentioned that you utilize experts in doing that. Do you use experts to just establish the uniformity of practice, or do you actually have to prove damages at that stage?
Yeah, good question, Yana. Thank you for asking the question. So you would not use damages to actually prove, or experts to actually prove damages at certification. We have experts come in that have particular industry expertise that might speak to how an industry works, if that's something that's important for the judge to understand. And that would be on both sides, plaintiff and defense. In a damages context, the place you most often see experts come in is on competition claims. And the idea there is because for the longest time there were arguments being put forward by the defense that, these price fixing claims have an inherent problem, and that often you're talking about a very small amount that might be passed down through several levels of a global distribution chain. And an argument that the defense would make is, how is that going to be calculable at the end of the day if this gets certified and the plaintiffs are successful at trial? How can you possibly determine what the damages are and make any form of distribution? And so that was an argument that was being put forward. Because it's a procedural gatekeeping process and not a merits analysis, the test that the court came up with, and I think it's probably the right one, frankly, although it's a low bar, is no, plaintiff does not need to show actual damages and run an actual calculation. They just need to show that there is a method out there, and usually this damage or this evidence would come from an economist. They just need to show that there's a method out there whereby you can look at all the factors, run some sort of typically a regression analysis, and have an expert say, yes, I can do this. I understand the industry, I understand the barriers to entry, I understand all the dynamics that go into pricing. I can factor and account for all of those things, and I could come up with a number at the end of the day to show you what the overcharge is. And that's the way that experts would be used on damages at certification. And so they just need to be able to show there's a way to do this, essentially, and that typically will satisfy the court. And like I said earlier, we've not yet had a competition claim go to trial, so we've never actually been able to fight on the defendant's side with plaintiff's experts on the actual calculations of the alleged damages. But one day that will happen, and there'll be new law, and there'll be all kinds of fights about that.
Great. Well, before they kick us off the stage, join me in thanking Damiën, David, and Ryan.
Thank you.